Last week, one of the nation's most prominent gender medicine experts was ruled to have misled the family court when giving evidence to support a mother who wanted her child to be prescribed puberty blockers. Justice Andrew Strum's judgment stripped the mother of custody, effectively preventing the child from accessing gender change medicine. Today, a former family court judge has suggested the landmark ruling could upend precedents which allow children to receive treatment without a court intervention. Stuart Lindsay told The Australian he's concerned about the impact of secrecy statutes and believes it could be in the best interests of parents and children for identities to be known. Joining me now, our legal affairs contributor at The Australian, Chris Merritt. Well, Chris, I think the circumstances of this case are pretty important. Take us through what was decided by the court and why.
Okay, this was a tragic case. It's about a 12-year-old boy. His parents split up. The mother has been taking this fellow to a transsexual gender clinic from the age of 6. He's now 12. She wanted to proceed on a course of puberty blocking treatment. The father objected, and that's how we got to court. And that's what needs to change. Had the father believed the misdiagnosis his former wife had received, that their son had suffered from gender dysphoria, there would be no role for the Federal Circuit and Family Court in running a ruler over this and just checking the rigour of that diagnosis. There's a precedent, and this is what the former judge was talking about. There's a precedent that makes it clear that if both parents agree and are not in dispute about a course of gender blocking treatment, it will go ahead without any further involvement of the court. But in this particular case, because the father objected, it found its way into court. And when the medical experts were subjected to a bit of cross-examination and their evidence was tested quite rigorously over a long period, huge flaws emerged. Some obvious treatments or obvious potential causes of the boy's gender confusion were not pursued. There was no attempt, for example, to test whether he suffered from autism, which can have an effect on gender confusion. So that needs to change. That's a role for the court itself. It needs to go back and have a look at that existing precedent and provide a role for itself in these cases. Because if we've got a misdiagnosis in this case, based on what the judge said was evidence infected with ideology rather than facts, there could be other cases like this proceeding. So you'd have confused young people proceeding on a course of life-changing treatment because their parents trusted the diagnosis of clinicians who have been clearly found to have engaged in some very sloppy practice once their practice was subjected to scrutiny by the court. Now, that's not the end of things. There's a role here for the next federal government as well. The judge made the point that it's a criminal offence to identify any of the witnesses involved in this case. So it's a criminal offence for anybody to say who these doctors are who gave evidence that was rejected by the court, but more importantly, diagnosed a young boy, wrongly as suffering from gender dysphoria. And had that not been picked up, this could have started him on a course of action that doesn't stop with puberty blockers. It's usually followed, or sometimes followed, by a course of opposite sex hormone treatment and, in the final stage, surgery, all based on a misdiagnosis. Now, that's incredibly significant, and that needs to be addressed by the federal government, the next federal government.
Well, we want to see both sides take a spine on an issue like this because, as you say, only for the fact that the dad called into question what was on the table in terms of treatment for his son, often, life-changing treatment, do we have this outcome. Otherwise, it would have just been waved through. Thanks for your time. Thanks for your time, Chris. Really important subject.